Good morning and good afternoon, good evening, perhaps, depending on where you're joining us from. We're so happy to have you here. But before I begin and say anything substantive, just a couple of technical details just to make sure that everyone can understand us as well as possible. We have two options. The conference is bilingual. All the presentations today will be happening in English, but over the course of the week, there will be some sessions and some presentations in French also. So we have simultaneous translation available. If you have the latest version of Zoom, next to your leave button at the bottom right of your Zoom window, you should see a little globe labeled interpretation. And if you click on that, that will give you the option for English, French, and also to mute the original audio. So that is an option. And then we also have live closed captioning that's available, but only in English. So that shouldn't be a problem today, again, because all the presentations are in English, but that's the CC box that's next to the interpretation button, and that's labeled live transcript. And when you click on that, you have the option of either having subtitles on your screen or having the transcript of the conversation next to the screen, the image. So we hope that these two affordances make the conversation a little bit more accessible to a wider range of folks. Good morning. My name is Ama Edo. I'm Assistant Professor of Anthropology and African Studies at MIT. And along with Liliane Mobieyi from Avocats Sans Frontières, it is really my great pleasure and honor to welcome you, our audience, and welcome our panelists to this morning's session. Liliane will be moderating, and I will let her introduce this very exciting lineup of people we have ready for you this morning, and that we're really looking forward to hearing from. But before we do that, I just wanted to give a brief overview before I hand off to Liliane of the symposium, and just to ensure to provide some continuity between today or yesterday and the coming days, and also to give you a sense of what's coming up. So broadly speaking, I think the core aim of the symposium, which I haven't given a name, the Justice Now Symposium on tackling legacies of Europe's colonial past in the wake of Black Lives Matter. Our aims really are, over the course of this week, are to consider what opportunities the present moment offers for moving forward both racial justice movements in Europe and efforts to address European nations' colonial past, right? What we're interested in is the intersection of these two movements. And so to kind of think through that, we thought it would be useful over the course of the symposium to gain both a historical perspective on efforts to deal with the colonial past, as well as a sense of the opportunities or possibilities that are available through institutions at different levels, right? So whether it be national, supranational, or regional, global, in order to see what's possible kind of from a policy standpoint. And so in all these perspectives, both historical and institutional, we wanted to get from a transnational as well as a transdisciplinary logic, right? And with a focus on alliance building across these different realms. So yesterday we kicked off the symposium with the first 2 of 4 sessions that provide this kind of like big picture on the colonial past, its injustices and violences. We had a rousing keynote speech by Diepo Lopeco, as well as a fantastic panel for the provocations that we entitled Provocations, that reflected on what justice should look like. And the focus of those panels was really what has gotten us to this moment when we're talking about the repair for the colonial and slave trading past, and thinking about justice for African and Afro-descended peoples. Now, today's session and tomorrow morning session, there's only one session today, tomorrow there will be 2. Today's session and tomorrow's morning open up 2 more of these theme-driven discussions across a range of geographic locations. Today's focus will be on ongoing and past movements for reparations from a range of locations. Again, I'll let Liliane introduce that. And then tomorrow's session will be on supranational opportunities, the opportunities available through institutions like the UN, the EU, foundations, or NGOs. And then after kind of these 4 sessions that I laid out, the 2 of yesterday, the 1 of today, and tomorrow's first session, we start with our country-focused roundtables. And there, the idea is to get a sense of the state of the debate or of the debate around racial justice and the colonial past in 4 European countries. And so we have a roundtable for France, the UK, Germany, and Belgium. And the idea there, again, is to bring together a range of perspectives. So a mix of academic, activists, and policy maker voices who are grounded both in the European country and also for most of the roundtables, there are contributors on the table who are anchored in African countries and involved in reparation claims or claims for justice with sort of the former colonial nation. So that's the general structure. So tomorrow afternoon, there'll be the French and UK roundtables running concurrently, unfortunately, because of time limitations. But then on Thursday, the day will start with the Belgium roundtable, and then will be followed by the Germany roundtable. And Friday, we begin with what we're calling very ambitiously and yes, in a dedicated fashion, the inter-country strategy session, where we're bringing together the panelists from all the country roundtables to now speak with each other, right? And all of the roundtables are moderated by someone from the country who's involved in efforts in that country in some form or another. And the inter-country strategy session will be moderated by the French journalist, author, and director, Rokhaya Diallo. And so we're super, super excited and honored that she will be joining us for that conversation. And then the symposium will end with the second session on Friday with Liliane and I hosting an open forum where we're hoping to get a chance to engage a little bit more with the audience, because on one hand, the webinar is a very nice medium, but we really miss seeing and kind of feeding off of the energy of the other folks who are here and hearing also from our audience in a somewhat more relaxed fashion than what the Q&A period can offer. So that last session will be a Zoom meeting as opposed to a webinar. And we're hoping that we'll get a chance to reflect together on what has transpired over the course of this week and the way forward and all that, and to learn together. So that's the basic structure of what's coming up for the next couple of days. And so at this point, I will hand off to Liliane to introduce our panel. Again, thank you so much for joining us, and we look forward to spending the next few days with you.
Thank you, Anna. Good morning and good afternoon, everyone. I'm thrilled to be opening this exciting panel on past and ongoing movements on reparations. And I'm happy to see that there are so many participants are joining us. Just a few words on the technical side of the panel, and then before we start the presentations. So the length of the meeting is 90 minutes, 60 minutes for the 5 speakers, and then 30 minutes of Q&A. For the questions, just make sure that you write them in the Q&A chat box, and if you can identify yourself when you write the question, that will be helpful. Before introducing the panelists and hearing from them, I would like to share with you a few words on the spirit of the panel. A few years ago, when I was doing my PhD research on apartheid victims movements, reparations before US courts, I realized that they had built their strategies and arguments upon other movements for reparations, from reparation and restitution claims from Holocaust survivors, and also from reparation claims for slavery in the US. And also that apartheid victim strategies were also being used to launch new claims in other contexts. So there was a kind of space in which arguments and strategies were circulating, strategies for reparations were circulating, being used and appropriated in each context. And this circulation was not only happening geographically, it was also happening in time. And so when the Black Lives Movement movements erupted and claims for restitution and reparations were expressed, it occurred to me that maybe there's something that we can learn from former movements for reparations, and maybe there are something or lessons that we can that we can learn and that we can use in contemporary claims. So the purpose of this panel is to give a glimpse of some of these processes of reparations. So we hear Professor Varen Shepherd presenting the Caribbean context, the claims that for reparations that have been expressed in the Caribbean context. And then Professor Magali Besson, who will talk about the reparation claims to France. And then Professor Suraj Rasool, who will be presenting the human remains and restitution of artifacts that have been addressed to for African countries. And then finally, and then before we will listen to Ms. Drisenheath, who will be presenting us the U.S. current debate on reparations for slavery. And finally, from a cross-cutting perspective, we'll hear Pablo de Greff, who will talk about the potential limits of reparations for historical injustice. With these different presentations, we would like to have to get a sense of the mechanisms that have been employed to bring forward the reparation claims. What are the hurdles these movements are facing? What worked well, and what seems to be promising. And tied to that, we also like to discuss the nature of the claims. For instance, restitution and restitution of artifacts, but also economic reparations, and how the nature of the claims will influence the choice of the mechanisms that are employed. So I will say a few words about each speaker before I introduce them to you. So our first speaker is Professor Varen Shepherd. She's Emeritus Professor of Social History at the University of West Indies. She's also the Director of the Center for Reparation Research at the same university. As a UN expert, she has played a role in drafting the program for the decade for people of African descent. And she has received several awards for her work in history, human rights, and gender. And also her work on collective memorials for historical tragedies is well known. Please, Professor Varen Shepherd, the mic is yours.
Thank you so much. Thank you for your introduction, and thank you for the invitation to participate in this forum. And I take the opportunity to greet the organizers and my fellow panelists. I have to say that I'm truly honored to be in such great company today, and I thank all those who have made time to join the panel on this e-conversation. Before I go any further, and as I do before discussions on reparation, I pay respects to my Tikar ancestors who were taken against their will to Jamaica. My great-great-grandfather, Alexander Mighty, who was born into slavery in 1829. The 428 enslaved people who worked on Hopewell Plantation and Penn in St. Mary, Jamaica, where I later grew up. Cuba, Mimba, Sue, Delia, Juanica, Ben, Ned, James, Cyrus, enslaved by the British enslavers, the Hibberts, who received compensation of £6,338 when slavery ended, while the enslaved got nothing but freedom, important as freedom is. Let me address now each of the questions posed to the panelists, starting with a brief overview of the reparations claims that have been brought in our case of focus, which is the Caribbean for me. The Caribbean reparation movement was formally initiated in 2013 when the CARICOM heads of government established a CARICOM Reparations Commission and mandated the formation of national commissions for reparation in member states. But the CRC builds on the work of indigenous peoples who struggled against conquest and colonization and insisted on their human rights. Enslaved Africans who opposed chattel enslavement, the newly emancipated in all of the Americas, who took up the struggle, protesting the attempts of colonizers to continue the relations of production of the previous era, indentured and post-indentured Indians who protested their treatment by plantation owners, Marcus Garvey, oppressed Rastafari, and labor rights activists in the 1920s and 1930s took up the struggle as they espoused Pan-Africanism, repatriation, and workers' rights. And of course, individual politicians and scholar activists and civil society partners. Today, those in the movement hold fast to the 6 R's that we say are the imperatives of the reparation movement, as we insist that we must collectively remember, reclaim, restore, and repair in order to secure rights and achieve reconciliation in this reparation century on behalf of the close to 5 million Africans forcefully relocated to the Caribbean, which is my example, who arrived alive up to 1811, despite the propaganda that the trade ended by an act of 1807. These justifications foregrounded the demands by Rastafarians in Jamaica for reparation and repatriation to Africa paid for by the British Crown. And they have been doing this since the 1950s, when they sent a telegram to Queen Elizabeth of England, Queen Elizabeth II, at Buckingham Palace, as you can see on this slide. In 1961 and again in 2004, a delegation of Rastafari presented a petition to the United Nations to persuade Europe to pay billions of dollars to the followers of the faith in reparation for slavery. In 2002, on Queen Elizabeth II's visit to Jamaica, another request was made, but the Queen, after replying that "I'll get back to you," Queen Elizabeth rejected the claim, saying that Britain could not be held accountable for the wrongs of the past. Rasta lawyer Miguel Loran also represented the Rastafari in a case against the Queen, at which Pan-African attorney at law and reparation activist Bert Samuels and others gave evidence. The Queen of England was represented by the Solicitor General of Jamaica, Michael Hilton, and argued before Justice Marsh, and the case was turned down. Other than that, claims for reparation have only been done through letters to heads of government of 6 European states in 2016: Denmark, France, Portugal, Spain, the Netherlands, and the United Kingdom, although others have been added since then, as you can see on this slide. The letter set out the reasons those countries were singled out and outlined the evidentiary basis for the claim, including the lasting impact of conquest, colonization, African enslavement, and post-slavery injustices. And the Durban Declaration and Program of Action, I think, states it very well in terms of the justification for reparation. The letter sent should be seen as the first practical step in entering a discussion around a development plan. So Rastafari presented the case for repatriation as part of reparation. The CARICOM governments have entered into a discussion or tried to enter into a discussion around the development plan. All the 6 states, well, 5 of the 6 states responded. Portugal did not respond, I believe. But the responses hardly addressed our demands. The British declared that they do not believe reparation is the answer. Spain suggested that it had already done enough by contributing to the permanent memorial to slavery at the United Nations headquarters in New York, and through the Spanish Development Cooperation, which has initiated educational programs for schools, designed, they say, to teach children and young people the history of the Spanish presence in the Americas in both its good and bad aspects. In the meantime, Cristobal Colon remains on the landscape in many parts of the Americas. Secondly, what mechanisms have been or are being employed to bring forward these claims? Where does the process stand? Well, since the sending of those letters, the focus has been on public education and civil society mobilization and international advocacy and the preparation of other strategies. One strategy that has been developed since 2013 is a 10-point action plan for development. This is the most important of these strategies. And you will see that it starts with the demand for an apology, for a development program for indigenous peoples, for repatriation for Rastafari and anyone who needs it. But in this repatriation discussion, we also take on board the issue of artifacts and documents which reside in overseas repositories to which we don't have access. But the Caribbean has also lobbied international human rights institutions like the General Assembly and the Human Rights Council. And some of us routinely bring this up in the Committee on the Elimination of Racial Discrimination. At least one national commission for reparation in the Caribbean is discussing a petition to the Queen's Privy Council. So how did the nature of the claims, for example, restitution of artifacts and economic reparations, impact the choice of mechanism? Well, for us in the Caribbean, restitution of artifacts is part of the overall claim, and as I said, would fall under repatriation in the 10-point plan. But it has to be understood that indigenous genocide, the transatlantic trafficking in enslaved Africans, enslavement and colonial extraction were large-scale systems that robbed Caribbean people of life, agency, and self-determination. Repatriation is about restoring our regional potential so the Caribbean populace can have the resources to live long, healthy lives with access to basic resources. So our situation requires a development plan and not necessarily a cash handout to individuals. The CRC's 10-point action plan and the Durban Declaration and Program of Action, plus the SDGs, which focus on poverty eradication, are therefore negotiating strategies addressing key areas where we have been systematically deprived: education, healthcare, technology, and infrastructural development, just to name some. The widespread nature of these claims requires mechanisms that can impact multiple areas. And that is why UN's framework, and we know that the UN has an interest in the right to development, was used, and why we are holding European governments responsible through direct approaches. Of course, grassroots activists prefer a more, I suppose, a different approach, let's say. And we are in discussions to see how we can meld both approaches. So how might the current state of international law or transitional justice mechanisms be useful for bringing forward reparations claims before European states? Well, for us, international law helps us to ground our claim in precedent. And I think we're all aware of the most famous cases: reparation extracted from Haiti by France, reparation paid to the Jews for the Holocaust, reparation paid to the British planters at emancipation. But I think that approaches to the United Nations treaty bodies like CERD, a legal case in the ICJ, and appeals to Her Majesty's Privy Council are being contemplated. But there are pitfalls in each, and they remain options, but we can talk about the pitfalls in the Q&A. In the end, I think we have right on our side in the Caribbean. Sir Ellis Clark, who was the Trinidadian government's UN representative to a subcommittee of the Committee on Colonization in 1964, had made this point in his statement, and I quote, "An administering power is not entitled to extract for centuries all that can be got out of a colony. And when that has been done, to relieve itself of its obligations by the conferment of a formal but meaningless because it cannot possibly be supported, political independence. Justice requires that reparation be made to the country that has suffered the ravages of colonialism before that country is expected to face up to the problems and difficulties that will inevitably beset it upon independence. We are aware that moral suasion alone will not work, that attempts at negotiation have not worked so far, even though CARICOM governments have recently committed to intensify the negotiation strategies. But small successes that result from lobbying have been achieved. And we have all seen them in the news. Banks owning up the Glasgow Center set up with the Caribbean, with University of the West Indies and others, universities, churches, financial institutions. Are we in the Caribbean deterred by the fact that there has been no positive response from any complicit European state in terms of a financial settlement, or even an offer to meet and talk? That while apologies, statements of regret, and promises have emanated from corporate entities, financial and insurance companies in the UK, there has been no outreach to us in the Caribbean, where their wealth came from. That while universities in the UK are busy studying their connections to slavery and the transatlantic slaving business, not one has invested a penny in the Caribbean in the form of a development reparation. The answer is no, we're not deterred. As Sweet Honey in the Rock sings, we who believe in freedom cannot rest until it comes. Thank you very much.
Thank you very much, Professor Shepherd. And thank you for giving this historical perspective where we can see that how these claims have been taking different shape through time and also being addressed to different institutions and different actors. I'm sure that we will have a lot of questions on the different aspect of this process. Let me now give the mic to Magali Besson, but I will first introduce her. Professor Magali Besson, she's a professor of political philosophy at Paris Panthéon-Sorbonne University. She is also a member of des Instituts des Sciences Juridiques et Philosophiques de la Sorbonne and an associate researcher at the International Center for Research on Slavery and Post-Slavery. Translating at the same time, so I hope it corresponds to what it is exactly. So her research focuses on theories of justice, theories of democracy, and critical theories of race and racism, on which subject she has written several books, her most recent book being Faire justice de l'irréparable. Please.
Thank you very much for the invitation, for the presentation, and thank you for the co-panelists, and my apologies to the translators because I'm afraid I'll be speaking fast because I have a lot to tell you, so yeah, apologies. So I was asked to present the reparations brought before France for slavery, and I'd like to start with the birth of reparations as a public problem. Reparations for slavery, slave trade and slavery came to the forefront of the French political scene at the turn of the 21st century. And it was between 1998 and 21 that they were constructed as a public problem. So 1998 was the year of the official commemoration of the 150th anniversary of the second and final abolition of slavery in France. It marked a turning point in the ways in which both the state and the civil society politicized the history of colonial slavery. For the French government, the commemoration represented an opportunity to present France as a nation that was certainly mixed and diverse, but also one and indivisible, united around universalist republican principles. Through the double reference to the date of the abolition of slavery, April 27, 1848, and to the beginning of the Second Republic in 1848 as well, this was the idea expressed behind the slogan, all born in 1848. On the side of associations, what now has become the CM98, Comité Marche 98, they seized the momentum and created or brought in front of the public scene the claim for reparations particularly through the march that happened on May 23rd that year. And this first moment, this first creation of the problem resulted in the adoption 3 years later, 20 years ago, we're celebrating this anniversary this year, on May 10, 2001, the creation of the adoption of the so-called first Taubira law, which recognizes the slave trade and slavery as crimes against humanity. However, while in its initial wording, born from this context, the law contained reparative provisions linked to the criminalization of colonial slavery, it was ultimately denied in its adopted final version any normative repressive scope or any reference to reparations. It is a strictly declarative law. It neither provides nor allows for reparations for slavery. It does not open up any reparatory right or entitlement. But it opened up a path towards reparations from the memorial side. So despite resistance expressed in terms of reparations as divisive claims or reparations as communitarian claims, and communitarianism is a bad word in France, or despite resistance due to the fact that reparations claims were intended to enhance feelings of repentance. So despite all these reparation or resistance arguments, specific initiatives were born and were actually born from the incentive of Articles 2 and 4 of the Taubira law, which focused on research and commemorative dimensions. So let me just mention a few landmarks, and of course it's impossible to mention everything, and yeah, but a few landmarks were particularly met with particularly important media coverage and triggered important debates. So first, in 2004, a national committee for the memory and history of slavery was officially created in France, and Maryse Condé, the French Caribbean writer, was its first president. In November 2019, this committee became a foundation for the memory of slavery, which is now still running. May 10 was chosen in 2006 as the official commemoration date in metropolitan France for the memory of slavery and its abolition. And May has now become a whole memories month with diverse events taking place both in metropolitan France and overseas territories. I cannot mention all the initiatives or events or cultural events that happen, but I just want to mention the Convoi pour réparations, which occurs in Martinique every year from May 10 to May 22. The fields of education and culture were also domains in which several initiatives took place. For instance, in 2015, there was a national annual contest called the Flame of Equality that was launched for schools, primary, middle schools, and high schools, inviting pupils to create projects on the memory of slavery themes, and we can discuss about that too during the Q&A. On the cultural side, I'll just mention the Memorial Act, the creation of a Caribbean Center of Expression and Memory of Slave Trade and Slavery, inaugurated in 2015 as well in Pointe-à-Pitre, Guadeloupe. So these are, again, only a few landmarks, just to give you an idea of the type of the type reparations or the aspect reparations actually was adapted in France. So there were commemorations, memorials, museums, exhibitions, targeted research programs, grants, research grants in history, archaeology, anthropology, etc., educational, cultural events. And these are obviously not only symbolic reparations. They are very material and they have financial implications. political limitations as well. But what I want to stress out here is that they were very multiple, they were very, and they are very opposed to, if we can consider them as something that actually worked, to reply to one of the questions that were asked, they have to be contrasted with failures of the or judicial processes of reparations. A few claims have been issued in the wake of the Taubira law, using civil law procedures in order to sue the French state. In 2005, two anti-racist and anti-colonialist associations, the MIR Martinique and the CMDP, sued the French state for its responsibility in the colonial slave trade and slavery in Martinique. Later, physical persons joined the claim. They demanded recognition of the state's responsibility in the crimes, the payment of financial compensation to both a reparations committee or foundation and to individual claimants. And they sought public funding for the creation of a committee of experts dedicated to establishing scientific knowledge related to the crimes and evaluating the current prejudice resulting from them. The first instance judgment was issued on April 29, 2014, and the judges rejected the claims on several grounds. First, as already mentioned, they claimed that the 2001 Taubira law did not create any right to reparation. Second, they claimed that the problem was actually related to a duty of memory, by which they referred to symbolic recognition and scientific knowledge. And this duty of memory, they said, was covered by law, but was way beyond the scope of a tribunal. And third, most importantly, the judges said that the action was time barred. They said, I quote, the demands of the claimants would be subject to a statute of limitations. The judgment was appealed and it was finally confirmed on April 17, 2019 by the Cour de Cassation in France, that is France's highest civil jurisdiction. And it was confirmed on the same arguments of non-retroactivity and statute of limitations. Another couple of cases issued by the MIR Guadeloupe and CIPN against different representatives of the French state also resulted in the same judgment. The judges rejected the claims based on arguments of prescription and non-retroactivity, and it was again confirmed by the appeal court in 2021, that is 2 months ago. The first action has been brought before the European Court of Human Rights, which has declared the case admissible in February 2020, and the case is pending, so we'll see what may happen there. From this very sketchy, very brief description of both aspects, the memorial aspects and the legal aspect of reparations for slavery, what now? Call for the need for a paradigm shift from backward-looking corrective justice in an ordinary corrective justice context to a forward-looking, transitional, and political transformative justice aspect. And I think that reparations should be concealed in this new paradigm rather than in the ordinary justice paradigm. So according to the criteria of the French tort law, the right to reparation requires the absence of prescription, the attested existence of reparable harm or damage, or relation between the harm and the event giving rise to it. And of course, this is particularly difficult in the case of reparations for slave trade and slavery. Two features of these injustices make reparations very unlikely to occur in the tort law logic. The fact that these injustices are not, strictly speaking, historic, but enduring injustices. That is, they are anchored in a distant past, and they are still producing oppressive racist effects. the second point is that they are structural and not interactional injustices. That is, the harm is the result of institutional proceedings, functionings, norms, social practices, playing a causal role in the production or reproduction of behaviors, unequal status, and their negative effects. And these features are particularly difficult to catch in the tort law individualistic, causal, and counterfactual logic. This is why I suggest that reparations should be viewed in a transitional justice approach rather than in a corrective justice approach. But by transitional justice here, I mean what Paul Grady and Simon Robbins recently called a transformative paradigm, reconstructive or reconstitutive paradigm, rather than restorative or compensatory paradigm. Reparations should not be simply part of a remedial compensatory frame in a backward-looking logic, but it rather be part of a transformative, reconstructive frame in a civic justice and forward-looking logic. In this perspective, what needs to be repaired is the social fabric of our society, valuable social relations between individuals, and shared political trust for our common institutions, which should be concerned with de-racializing the society and realizing real, and not only formal, real equality. Such a paradigm shift from ordinary corrective justice to transitional justice requires that we accept that our society is a deeply divided society and hierarchical society, in which the socio-racial hierarchy inherited from our colonial past is still massively meaningful and significant, and where socio-racial divisions also have political salience, and where what matters is not who we are, but what we want to do together. Reparations in this view would mean acknowledgement of the past and present injustices and recognition of the equal worth of all citizens. They may include participatory, inclusive public institutions, regional and urban policies of equalizing access to resources and to public services, existence of a real formal and informal public sphere favorable to the expression of racialized minority discourses and voices, public funding of anti-racist and decolonial associations instead of forbidding them, as is nowadays the case in France, restitutions, public apologies. Such measures would testify that state power is committed to the path of justice by transforming our socio-political structures in depth and aiming at the normative reconstruction of a new political, really inclusive regime. Thank you.
Thank you so much, Professor Magali Besson. I found this this perspective, this new paradigm, this shift that you suggest is quite interesting, and I'm sure that we have many questions from the audience. I will now give the mic to Professor Siraj Hasan, who is a senior professor of history at the University of Western Cape, where he teaches museum and heritage studies and also curatorship. He was previously chaired of, has previously chaired the scientific committee of the International Council of African Museum and has served on the board of the very renowned District Museum in South Africa. Professor Siraj Hasan, the mic is yours.
Thank you very much, Lilian, for your kind introduction. Thank you so much to you and to Amar and to all the colleagues on the panel. This is an extremely busy field right now. Just yesterday, we learned that a decision was made in Berlin that as part of the making of the Humboldt Forum, the controversial making of the Humboldt Forum, no artworks and artifacts from that were looted in Edo state in Benin by the British so-called punitive expedition will be put on display, and that the Germans will immediately enter into discussion with Nigerian colleagues about the restitution of those objects. And so there are developments every day. My own involvement in this area goes back to the turn of the 20th century, when we were immersed in tremendously exciting developments about transforming old museums and making them fit for a democratic society, and in making new museums, such as the District 6 Museum. And in that process, one of the most troubling displays that stood for about 5 decades in the front hall of the South African Museum in Cape Town was an exhibition of Khoisan people gathered together in a camp with huts, with people in hunting poses, which really consisted of body casts that had been made in the early 20th century, placed into an invented scene of culture. And these were casts that had been made from living people, were farm workers and shepherds, and that were made by James Drury, the cast maker at the then South African Museum, after the urging by a visiting anthropologist at the joint meeting of the South African and British Associations for the Advancement of Science, for the physical attributes of these fast disappearing people to be documented. And so that display and the existence of body casts was at the center of the debate and discussion about how to transform museums. How do you make these museums fit for a new nation, a democratic nation? My colleague Martin Legasik and I started doing research on the origins of the modern museum in South Africa. And it was very interesting to discover that at the same time as these casts were being made, museums in South Africa were purchasing skeletons that had been illegally disinterred from their graves as part of a trade in skeletons and human remains. And so that the human remains that were to be found in South African museums were in large measure not the remains of long dead people, perhaps excavated by archaeologists according to archaeological standards and so forth. These were indeed the remains of ancestors that had been plundered from their graves and brought into the museum. And along the way, we encountered the activities of a visiting Austrian anthropologist by the name of Rudolf Perch, who in 1909, together with a team of assistants, organized for the disinterment of skeletons and human remains from their graves, people known in life, people who we can name today, and people who were farm workers and who came from communities perhaps of Mu-speaking people who lived in the Caraïbes area between Namibia and South Africa, from communities that had been maybe put to flight under the circumstances of the German genocide in southern Namibia, of Khoikhoi and Ochi Herero speaking communities. So in a landscape of violence, you had the activities of this Austrian anthropologist collecting human remains, went into the field with film equipment, the earliest field sound recording equipment, and took photographs and collected material culture. All disciplines involved together, and Rudolf Perch was eventually appointed the first anthropologist, first professor of anthropologist in Austria. Very interesting situation, how Perch, the work of Perch was facilitated by the Germans and by the British at the Cape, and that what you had here was the South African institutions competing with with European scientists. And what was happening here was not that the South Africans were against this kind of activity, but they preferred that these human remains remained in South Africa, and that the South African museums and universities should indeed become the recipients of what was regarded as the remains of living fossils. So we have this extremely difficult history of museums in which the body casts, in fact, acted as an alibi for really a nefarious legacy of the modern museum. And we had a debate in South Africa with some anthropologists saying, you want to remove these human remains is tantamount to burning my archive. And what we had was eventually the South African Museum incorporated into a new national museum structure called Iziko Museums of South Africa that made the decision that these had been unethically collected. And those remains that had been collected for the purposes of racial studies and all that had been collected for the stolen from their graves were deemed to have been unethically collected and set aside and prepared for restitution once South Africa had prepared a restitution policy. Our purpose was to transform museums in South Africa. But along the way, as I said, we had uncovered this nefarious history of the presence of an Austrian anthropologist in South Africa. And that led us in 2008 to being invited to Austria when our Austrian colleagues were involved in a project to celebrate Perch as the founder of media-driven scholarship, as the founder of many disciplines, and they were bringing together his collecting legacy that had been divided between all of these institutions in Vienna. And we put to them what the real legacy was of their founding father. We put to them, we read to them from our book, we presented the case to them, and our colleagues were embarrassed and in a state of embarrassment and in emotional trauma. And immediately restitution was offered. To cut a long story short here, South Africa underwent a negotiation with Austria. I was fortunate to be able to be part of the negotiation team. And what was achieved was a return of the remains of Klaas and Troy Pinaar through a project that was described as one of rehumanization. It was something insisted upon by the South Africans, something that initially the Austrian side refused to even contemplate because they said Austrian law, European law does not allow for skeletons to be returned as the remains of people. But the South African diplomats in Vienna worked away at this, and this was achieved in 2012. That was meant to be the first stage in a restitution process that would involve the identification of more human remains, because we have been able to name at least 3 more people whose remains were collected as part of the same expedition, transported on the same ox wagon. We've also been able to identify rocks with rock engravings that also were illegally chopped out of the earth and illegally exported. And we can draw attention to an entire collection of material culture, sound recordings, film, that needs to be negotiated between Austria and South Africa. And I'm very pleased to say that when I was last in Vienna, we had some very productive meetings with our Austrian colleagues, where in the new climate of restitution and of so-called decolonizing museums, there is a much greater willingness to engage in these kinds of steps and to really contemplate the possibility of restitution. With that experience that we had in South Africa, I was very pleased to be able to work with colleagues in Berlin, our colleagues at the at the Museum of Early History and Prehistory that are the focal point for the remains that exist in Berlin, and that out of which it was discovered there were almost 1,000 remains from Rwanda that had been assembled by the Polish scholar Czekanowski, sent to Germany and in about 1907 and 1908. And together we worked out a process of how it will be possible to engage in a restitution to Rwanda, where you have the possibility of the remains of colonialism and racial science being returned to a society that has had to face a trauma of a genocide, and where human remains have a particular saliency in that society. So there are a couple of points that I need to make here. It is very clear that, unfortunately, our discussions of restitution of human remains and the restitution of material culture have been artificially separated from each other, because it is very clear that the very same people who collected human remains also collected material culture and made sound recordings, and that to go through the restitution of human remains, which seemingly is easier to understand and easier to appreciate for the violence that is associated with that kind of collecting and that kind of legacy, that legacy has been artificially separated from the material culture. Now, there has been movement, as you know, since the publication of the Savoy report in 2018, that mainly addressed former French colonies and mainly French West African colonies, and where you have an extremely limited number of returns proposed by Emmanuel Macron, and that have been underway, because in general you have this tremendous problem of the principle of inalienability, something that also applies in Britain and other European countries, where there is a legal edifice that protects the presence of material culture in these societies. So we need to find a way to connect human remains with material culture, and we need to ask ourselves what restitution means. One of the big discussions that we need to have, because restitution is not simply an event of transportation. Yes, it involves political and legal strategies, and it has to involve African claims making. It cannot just be a process of European gift making, as European museums seek to place themselves on a more ethical footing. We need to ask what restitution will do as Africans. We need to ask what the meaning of restitution will be. We have some new opportunities coming our way. We have an incoming president of the African Union who has placed restitution high up on his agenda for the work of the African Union, because this is an opportunity for us to complete, indeed to add to the sovereignty of African societies after independence, because that sovereignty that was achieved with independence was a partial sovereignty, because you're talking about this extremely problematic history of artifacts acquired through some of the most violent acts that are supposedly cared for in museums in Europe. And this is a situation which increasingly is completely and utterly untenable. And it must be the case that questions of restitution have to be placed high up on our agenda in international discussions today, alongside questions of reparations and all of the other processes of repair that we need to undergo in order to produce, in order to deepen the democratization of the world, and in order to arrive at a museum that not only it's a museum form that is appropriate for a new world. Thank you.
Thank you so much, Professor Suraj Russell. And thank you for this perspective and this question on what do we mean exactly by restitution? How do we consider restitution of human remains compared to material cultures? And also how this question is brought into international relations framework, and how these different states and international organizations are engaging on these questions. Here again, I think we have more questions in our Q&A questions. I will move now to our next speaker. It's our next speaker, Dresden Head. She's a researcher and advocate in the US Human Rights Watch program, examining and advocating on racial justice issues. She leads the domestic research and advocacy on reparations and reparative justice. Her most recent research concerns the 1921 Tulsa race massacre, on one of the most incident of racial violence in the US history. Please, Dresden Head, the floor is yours.
Thank you so much for the invitation and to the organizers for such a rich discussion. I'm so grateful to the work and expertise of my fellow panelists. I'm going to give you an overview of the current situation in the US, the debate on reparations for slavery, but also the active movement for reparations for slavery. Grave and serious harms suffered from the impacts of the legacy of slavery include exploitation, brutality, forced labor, sexual violence, and other abuses within the institution of chattel slavery itself, but also post-emancipation racist policies, institutions, and practices that were established to further suppress every aspect of Black life, which further entrenched structural racism, creating an inescapable cycle of harm, which the effects of which we continue to see today. Those harms and victims' experiences are broad and wide-ranging, and the demands seeking to obtain full and effective reparations for those claims are not new. This has been a long struggle, really dating back to the first formal petition for reparations for uncompensated labor by Belinda Royale to the Massachusetts General Assembly in 1783. Followed by more formalized grassroots efforts pursued during the 1800s all the way through the 1970s. The modern reparations movement has been defined by the efforts of legacy reparations groups and COBRA, National Coalition of Blacks for Reparations in America, which pushed vigorously to educate the public on reparation and sought to advance remedies not only through legislation, but also litigation. Followed by NARC, the National African American Reparations Commission, founded in the early 2000s, a consortium of activists that furthered their concept of repair through a 10-point plan and other informational initiatives. Most of the court claims brought by descendants of enslaved Africans in the US have been thrown out by the courts due to statute of limitations or other legal barriers. So judicial remedy has not been realized in this context. But to this day, we still, the full impact of creating these laws and policies that force hundreds of thousands of Africans to be enslaved in the US, which constitutes, Durban declared it as a crime against humanity. It's also a gross human rights violation, has never been examined, accounted for, or assessed at the national level, nor has the government provided adequate redress proposals. So the trauma of this violence and the cruelty of the institution has been passed down in a variety of ways through generations. In addition to mental and physical harms, enslavement has also rendered severe economic damage, which has hindered Black people's ability to obtain and accumulate intergenerational wealth. But the heart of the reparations for slavery debate can be centralized through this primary legislative vehicle, for reparations for slavery, which is HR 40, House Resolution 40 in the US Congress. HR 40 is the commission to study and develop reparations proposals for African Americans Act. It was first introduced by the late Representative John Conyers in 1989. It's important to note that that is 1 year after the Civil Liberties Act of 1988 passed, granting redress in the form of financial compensation, education benefits, and pardons for wartime incarceration crimes against Japanese Americans and others who were wrongfully incarcerated and relocated during World War II. HR 40 is now currently in the hands of lead sponsor Representative Sheila Jackson Lee from Texas. The Senate companion S40, introduced by Senator Cory Booker of New Jersey, is the first reparations bill since Reconstruction to be introduced. This HR 40's lifespan is 32 years old. But it's important that we acknowledge that the bill establishes a commission to investigate the legacy of slavery, so the institution, and then post-emancipation racist policies and institutions, Black codes, Jim Crow segregation, race massacres like the 1921 race massacre, racial terror lynchings, mass incarceration, the policing institution, which evolved from slave patrols and was built to surveil and profile Black people, housing discrimination, gender discrimination. All of these have racialized impacts. More importantly, though, this commission will develop repair proposals. So this is not just a study bill, it is a remedy bill, and you have to fully diagnose the problem before you treat it. Despite lagging in the congressional chambers for this long, HR 40 has unprecedented momentum that was really fueled by the ongoing racial reckoning from the summer and fall of last year that, quite frankly, has continued, though the media has not covered it as intensely. The bill has over 169 co-sponsors, which is an incredible amount for a bill like this, for any bill for that matter. Advocates, including myself working on the bill, expect to see it voted out of Judiciary Committee, which it has never been voted out of subcommittee before, and then voted on the House floor in the coming weeks. There are real obstacles in the Senate, but President Biden's administration have now been on record this year multiple times signaling their support for the bill. And quite frankly, they could also, President Biden could also establish the HR 40 style commission through executive action, knowing the political realities of the Senate. We are in dire circumstances, right? We have COVID-19 has disproportionate impacts on the Black community. Black people are 3 times more as likely to be infected, 2 times more likely to die than white people. And this is a preventable disease. January 6th reminded us of white supremacist extremism being on the rise and the threat of not actually dismantling and expelling white supremacy, which is a long racialized violent history of this country. But let me just kind of outline why it's important today to realize the impacts of enslavement of Black people continue to this day. The Black-white wealth gap is as large as it was in 1968. The median white household has 41 times more wealth measured as a sum of assets held by a family minus the total household debt than the median Black family. Schools that serve Black and brown students have $23 billion less in funding. Systemic racism has left Black people with symptoms of post-traumatic stress disorder, harm to their immune systems, premature aging. Racist housing policies have left communities in areas with more harmful environmental factors, such as air pollution and toxic waste, which impacts health outcomes and life expectancy. Infant mortality and maternal mortality rates are higher for Black children and Black women compared to white women. The suicide rate for Black children is rising faster than any other racial and ethnic group, and is the second leading cause of death for Black youth aged 10 to 19. End of life care under Medicare is over $7,000 more expensive than Black individuals compared to white individuals. So dying even costs Black people more. You have, of course, the police violence epidemic as well. 1 in 1,000 Black men and boys in the United States can expect to die from the police. So these are the realities of the legacy of slavery that need to be accounted for. And at the local, so we have that federal remedy situation, but at the local and state level, there have been movements. Just yesterday, a historic victory in Evanston, Illinois, a suburb of Chicago, the first city to authorize implementations of reparations for Black residents in the US. This is the first remedy proposal, which earmarks $400,000 for $25,000 grants for home ownership and improvement, as well as mortgage assistance, particularly for Black residents who are descendants of people impacted by the city's discriminatory housing policies between 1919 and 1969. But this is just one piece of a larger plan, which will use $10 million over 10 years, collected by the city, primarily by levying a cannabis tax on sale revenue. These efforts are happening in addition to Evanston, in Chicago, Amherst, Massachusetts, St. Paul, Minnesota, Burlington, Vermont, Providence, Rhode Island, Asheville, North Carolina. The state of California passed its own state level HR 40 commission. Universities such as Georgetown and universities in Virginia are taking on reparative measures. Religious institutions such as the Episcopal Diocese of Maryland, Texas, and New York combined has pledged millions towards reparations funds, in addition to theological seminaries joining this effort. The largest union-owned bank, Amalgamated Bank, was the first major bank to endorse HR 40, and HR 40 has a wide-ranging existence of endorsements. Obviously, there are political, legal, and social limitations to what this process will actually look like. Political resistance to reparations for Black people in general has been fueled by anti-Black racism, failure of government culpability, and politics around victimhood. And past federal reparations efforts have had support from both parties. The National Indian Claims Commission in the 40s was a bipartisan effort, though wholly inadequate and not proportional to genocide, land theft, and other massive crimes to Indigenous and Native people. That was bipartisan. The Japanese American redress bill and the commission that studied to provide those proposals was bipartisan. There are arguments that these claims are divisive, but nothing is more divisive than entrenched racism. There are arguments that slavery was 150 years ago, or that no enslaved person is alive. But it doesn't matter how long ago a crime was, and it certainly does not stop us from incarcerating Black and Brown people for older crimes, leading to over-incarceration of these groups. The impacts of slavery, as described earlier, are ongoing, and therefore remedies must be administered for past and ongoing harms, a point that some of my fellow panelists have also made earlier today. And you also have a situation of, while important, you have lesser proposals that don't equal the weight of a reparations commission, such as a resolution in US Congress that simply urges the establishment of a truth, racial healing and transformation commission, which really falls short of what's needed to take a meaningful step towards a full accounting. We need to be talking about solutions and concrete remedies. We are 150 years after the government promised restitution via 40 acres and a mule. Political compromises, quite frankly, have always happened on the backs of and at the expense of marginalized communities, in this case, Black people. Offering a congressional resolution that is just an expression of Congress instead of taking steps to advance repair may further entrench these harms. And quite frankly, the Truth and Reconciliation process as we know it is built into a reparations commission. There are complex discussions around eligibility, and there are splinters within the movement, but this is exactly why we need the commission, right? My brief thoughts on this are, it's complex, and it was designed to be so. The slave trade obviously was international. People bounced back and forth from the Caribbean, from South America to the US. But ongoing discrimination such as housing segregation, lack of access to food, police violence impact all people who identify or present as Black people. We also have to encounter the destruction of records and papers to provide proof of one's ancestors' enslavement. It wasn't until the 1870 census that enslaved Black people and newly freed Black people had their names actually recorded in the census. So prior to that, we're talking about merely statistics and tick marks underneath the white slaveholders' households. So there's a lot to unpack here. There's also a general lack of understanding of education around what reparation entails. Our US education system was built by the Daughters of Confederacy. So there's a need to, transform what we constitute as mandatory political and social education. I know I'm running out of time, and I hope I get to talk further within the Q&A, but I just want to briefly say that, again, under international human rights law standards, the remedies should be proportional to the harm. So in the case of chattel slavery and its various evolutions, all forms of reparation must be on the table for the centuries of harm. That includes return of land, other restitution measures, return of opportunity and artifacts, financial compensation for lost wages during enslavement, bank discrimination, employment discrimination, psychological services and trauma-informed care, although supportive legal services to help advance claims in the courts, economic development, capital measures, targeted investments as a result of specific harms. We also need an official apology by the government that has never been instituted, memorials, museums, historical markers, and guarantees of non-repetition, institutional and legal reform. The criminal legal system and the violent policing system do not function to protect Black people or provide public safety more broadly. Through the 13th Amendment, we still allow slavery and forced labor through the punishment of a crime. So the national government, cannot continue to avoid accountability and culpability, while states and locales and institutions advance their own reparative measures, as the injury will be compounded and the remedy being greater over time. Thank you.
Thank you so much, Teresa, for giving us this this perspective on the current US debate, and also how it's important to keep in mind that whereas there's evolution on this debate on reparations, there are still ongoing harms and racism and structural inequalities that have to be taken into account while we think about reparations. Thank you so much. We will move now to Pablo de Greff, who is Senior Fellow and Director of Transitional Justice of the Transitional Justice Program at the Center for Human Rights and Global Justice of the School of Law at NYU, New York University. He has also been the Director of Research at the International Center for Transitional Justice, and he's been the first UN Special Rapporteur on the promotion of truth, justice, reparations, and guarantees of non-recurrence, a position that he held until May 2018. Thank you so much, Pablo, for joining us, and we are here.
Thank you very much, Lydian. I want to start by thanking you and for the very kind invitation. And also to say that it is a pleasure to share the session with my co-panelists, who in fact have touched upon many of the topics that I was asked to address. And the basic question was, what is the role of a transitional justice framework in the context of discussions about historical justice? So I will address that point. I think that one of the main contributions that transitional justice can make to the debate is the same contribution that it has made to other debates about more recent massive violations of human rights. And that is a point about the importance of the disaggregation, but at the same time, the coordination of different kinds of responses to justice claims, which involves both a dimension of redress, but also a dimension of prevention. So just for the sake of clarity with a broad audience that I unfortunately cannot see, but I will clarify that the typical transitional justice policy, a comprehensive transitional justice policy includes minimally 4 different elements. One of justice, typically understood in terms of criminal justice. For the sake of this discussion, given that the violations were historical, it's not so much criminal, but certainly civil justice that is absolutely relevant. The typical model of a comprehensive transitional justice policy also includes a very important dimension of truth-telling, of reparations, and of guarantees of non-recurrence. And around those 4 core elements, there are, of course, there's the possibility both of adding some, but of disaggregating some of them. And Siraj, for example, has emphasized correctly the importance of memorialization in different types, through different types of activities, initiatives, and institutions. So one question that is totally relevant for this discussion is, what have we learned during the last 30 to 40 years in the transitional justice field that may be relevant for this discussion? So the first and perhaps obvious point is that there are some violations that are not forgotten, that cannot be swept under the rug, no matter how long ago they may have taken place. People do not forget. The second important lesson is that, of course, there are violations that leave in their wake consequences that are transmitted intergenerationally and that need to be addressed. A third lesson is that a comprehensive and holistic policy that includes those 4 elements that I have mentioned works. It works not in the sense that it transforms reality into paradise. There is no such thing, but it works in the following important senses. It provides recognition to victims, and not just in virtue of the suffering that they endured, which of course is unspeakable and which deserves respect. It provides recognition to victims in their character as rights holders. And I think that this is fundamentally important. A comprehensive policy can also foster a minimum sense of trust between citizens, but also trust between citizens and institutions, which is absolutely indispensable for the sustainability of the notion of a shared political project. A comprehensive policy can also strengthen the rule of law, not the least by emphasizing that the violation of rights should not remain inconsequential, and that there is a basic equality of all in front of the law. And finally, I think that a comprehensive transitional justice policy can promote a certain type of social integration, which is also important for the sustainability of the idea of a shared political project. Now, I want to emphasize, although I cannot spell out the argument here in detail, that these four goals, recognition to victims, civic trust, the strengthening of the rule of law, and the promotion of social integration, are not merely desirable goals, but all of them are both a precondition and a consequence of a formal system of rights. So in fact, what we are trying to achieve is the affirmation of the importance of the idea of equal rights. Now, more concretely, I think that there are some contributions that have been, some lessons that have been learned in transitional justice that are perfectly relevant to this debate in the domain of justice. And again, I emphasize that here the crucial one is civil justice for this discussion. Transitional justice has taught us important lessons about addressing some of the problems that Professor Besson addressed, including retroactivity, prescription, and how to mitigate the effects of amnesties. In the domain of truth-telling, which is perhaps the domain in which transitional justice is best known, transitional justice has helped not only to entrench a right doctrinally, but in practice through the establishment of truth commissions, commissions of inquiry, and other truth-telling initiatives. In the domain of reparations, similarly, I think that there are two important lessons that transitional justice can teach us for these discussions. First, it has once again given life to a right to reparation on the part of individual victims that was relatively fictional, to be perfectly honest. Obviously, there's a long history of interstate, post-bellum, post-war reparations, but the idea of administrative reparation programs that address individual victims of violations is something to which transitional justice has contributed, and again, both in doctrine, but also in practice. And similarly, in the domain of guarantees of non-recurrence, the contributions are complex, but they include many of the initiatives that have been mentioned by the former speakers, and therefore I will not repeat. I guess that in the minute that I have left, I would like to make a couple of recommendations about transitional justice. It is a relatively young field, and as all fields that have become formalized very rapidly, it also shows a tendency, which I do not support, towards what economists call isomorphic mimicry, the idea that the very same institutional formations work equally well regardless of context. And I think it would be a very big mistake to simply adopt the transitional justice model and apply it to the case of historical injustices. I think that the spirit and some of the lessons are perfectly applicable, but the mere replication of transitional justice institutions would be less than adequate. The second recommendation is that these discussions tend to be framed exclusively in terms of reparations. And in my 25 years experience of dealing with governments, governments understand reparations reductionistically, largely in terms of compensation. And I think that reducing reparations to compensation would be a huge mistake. One of the lessons that we have learned precisely out of the disaggregation and the coordination that I was talking about before is about the importance of the complexity of reparations, complexity in the sense of creating programs that distribute a wide variety of benefits that cannot be reduced to anyone, and that furthermore are coordinated with one another. In the case of historical injustices, we need, for example, a great deal of socialization of truths that are known by experts, but that are not, as Dreisen pointed out, sufficiently socialized across society. But even within the domain of reparations, I think that beyond compensation, so I don't want to be understood as arguing that money is unimportant. It is important. But in addition to compensation, I think that there are very important measures that should also be discussed that have to do, for example, with the conditions of trade, with anti-corruption measures, both in donor and in recipient countries, with some of the other initiatives that were again mentioned by my predecessors, so I will not elaborate, but that include, for example, the support that many countries give to regimes that show absolutely no respect for human rights, and that benefit and are a way of continuing a form of despoliation which has not just economic consequences, but also consequences at the level of culture. And perhaps the final point that I will make is that I would not frame this in terms of a debt that we have with the past. I think that I would frame this much more as creating the conditions under which people can trust one another as legitimate members of a political project that they can call with justification a shared project. How we treat others says a lot about ourselves. And the question that I think that we are facing in the US and in Europe is, are we happy? Is it okay with us to turn the Mediterranean, for example, into a giant and voracious liquid graveyard? Are we okay in the US to have a militarized police force provide quote unquote security to some citizens rather than others? That doesn't seem to me to be a description of the conditions under which people can trust one another. So I will stop here. I think that there is a contribution to be made, but I don't think that it should take the shape of a mere repetition of past transitional justice experiences. Thank you very much.
Thank you so much, Pablo, for your recommendations and for your warnings on what we mean by reparations, maybe on this reductionist approach on compensation. We are running out of time, but I will try to to have time. We're gonna take time for questions. We have received many questions, but I think before we jump onto this question, I think what it's important to observe throughout all your presentation is that all the reparations processes have been very quite long and complex. So it's not something that happened in 5 years. In most of in the different contexts, it's we're talking about decades of mobilization and mobilization not only at the civil society but also within different spheres of the states. And I also found this perspective on the limits of the legal institutions to address the reparation question very interesting, and how maybe if we move the debate in the Congress or in the political debates, it can be interesting, but we also face hurdles. But at the same time, if we think about this question internationally, if you address it in the context, in the framework of international cooperation, international relations, it takes a different flavor, and it's also much more complex. And one thing that was very evident in the different contribution is how reparations, it's of course it's about the parties, but it's much more than the parties, also dealing with the present, and that has been very that appeared in every of your contribution. So I will try to take some of the questions that have been sent by the audience. So one question for Professor Siraj Rasool. An argument often raised against restitution of artifacts is that the African countries or institutions don't have the means to adequately care for these objects. How do you respond to these arguments? Maybe, I'm sure that it's a question that you are used to deal with.
I will deal with some of the questions that have come up in the Q&A, and I will also relate this to a thread in the discussion, in which clearly one of the circumstances for this work, this restitution work that we have been doing, is obviously the work of the Truth and Reconciliation Commission, and the criticisms that we've had of the work of the TRC and the limited frameworks that it has had for understanding what apartheid was, for not carrying through with the state not carrying through with prosecutions, and with impunity, and finally also with the centralization of symbolic reparations in a highly centralized narrative of the making of freedom, as represented in the work of Freedom Park in Pretoria. But one of the major achievements after the TRC has been the work of the Missing Persons Task Team in the recovery of the remains of guerrillas and anti-apartheid fighters and people executed by the apartheid state, and doing the work of sifting through the evidence and reuniting the dead with families. And this has led us to insist that when we work with the colonial dead, we need to connect these different deaths of South Africans in the different histories of atrocity, and to ensure that we understand the connection thereby, and where the restitution of the dead body is fundamentally a significant aspect of repair. Now, whether transitional justice provides that framework, I'm in two minds about, because transitional justice has given rise to a kind of professionalization and a removal of initiative from the people. And instead, what we are now arguing for is a framework in which I want to call a forensic museology. And this comes out of work that we do with our colleagues in my department who work on forensic history. So yes, that particular comment in the chat is one of the old tropes of restitution, that the Africans don't have the capacity, they're not ready, and that, quite frankly, it is something that is just patently untrue, and quite frankly, it does not have authority, because you're talking about a process of an ethical process where museums are ethical institutions placing themselves on an ethical footing, and where these are projects that are based on claims that are made. Now, with regard to Benin bronzes, we have the creation of monumental institutions that will be able to take care, that will be able to attend to questions of care and preservation and so forth. On the return of human remains, these are new matters for all societies. Of course, we can apply the framework that we have applied to the return of the dead of world wars. That there are frameworks that we can try to apply to this, but you're talking about what is essentially a return of remains to families and to communities, and to ensure that the dead are buried close to where they were originally buried, or close to where their families are. And these, of course, there is no model, there is no template for how you do this. These are precisely the challenges that we have to undergo to ensure that restitution is not events driven, but that it creates opportunities for healing in practice, that as many people as possible can be involved with. And of course, the Body Worlds exhibition, you know, that is a display that skirts the edges of the ethical. That is generally an anatomy education display that involves the donation by the dead of their bodies to science. Except the difference is not used for medical students. This is used for educating the public. You know, they went to a stage a few years ago of placing these plastinated corpses into sexual positions in order to demonstrate the anatomy of sex. And of course, that was found to be completely beyond the bounds. But that is a very different discussion to a discussion of human remains that were collected as part of colonial conquest, that was collected from the battlefields of conquest, and that were collected as part of the racial study of conquered people. You know, so you're talking about a complete, you know, a turnabout in embarking on projects of rehumanization that will ensure not just the rehumanization of the dead, but that also ensure a rehumanization of Europeans who engaged and their descendants who bear the legacy of those atrocities.
Thank you very much, Professor Russell. Professor Shepherd, sorry, you have raised your hand.
Thank you. I just wanted to say very quickly that I don't even think that I thank Professor Russell for his extensive answer, but honestly, I just think the simple answer is that it's not your business. You took something illegally, you took away people's remains, you send them back to their country of origin and let Africa decide how it wants to deal with it, not your business.
Thank you very much, Professor Shepherd, for this clear answer. Let me take another question for Professor Maguili-Besson. You mentioned the need to reframe reparations as the recognition of both past and present injustices, to look at them as transformative, as reconstituting the social fabric. What mechanisms seem to be available for this approach to reparation within the French judicial system? Or does the EU appear to be a more promising avenue?
Well, thank you for the question. So the short answer again would be, in the French judicial system, none. And I don't think that the French judicial system, as it is now, so maybe we can talk about potential evolutions or changes, but as it is now, there's nothing in the French judicial system that may achieve the transformative and reconstructive approach I'm advocating or pleading for. This is why I think that the solution or reparations should take a political and not judicial form. And by this, I mean what has been mentioned by several of the co-panelists. And among these political and not judicial dimensions, of course, institutions, for instance, are one of the political important aspects, but also legislative commissions, such as the one that was just created in Belgium, for instance, and there is nothing like that in France. Official apologies, none was ever pronounced. And these are only, well, police reforms, as Dreisen mentioned about the US, judicial reform, police reforms. Well, these are some of the idea that I have in order for France to kind of turn its back, or let's say for France to actually write the page that has never been written about its past, recognize it, and try to face it together in order to have a shared political project, which is obviously not in order these days, considering the level of the debate about, you know, I mean, about these issues in France these days.
Thank you. There's also another question for Dreisen Head. Due to the political opposition that the creation of a truth commission at the national level in the US will entail, don't you think that the establishment of this truth commission will be concretely too difficult to achieve? Maybe a local based and bottom-up approach will be more likely to succeed? That's a question, yeah, for Dreisen.
Thank you for the question. You know, I think what I often really struggle with in this debate is centering the debate around whiteness and resistance and political opposition, and that we should be advocating for victims of the legacy of slavery and ongoing discrimination to receive the full and effective remedy that is necessary. We've done this in the past for other groups of people. It may have been inadequate, but it was a step towards this journey towards repair. I understand the political realities, and you know, again, that's a byproduct of systemic and institutional racism. But you know, slavery was a national policy. Redlining was federal policy. Highway construction was federally financed. Urban renewal programs were federally, you know, instituted and carried out by local governments. The war on drugs modeled through federal initiatives. There has to be full documentation and accounting from the federal level. And I think, honestly, we're seeing aspects of a bottom-up approach because, you know, federal progress has been stalled for so long. All these measures that I referenced before happening across cities, across religious institutions, across education institutions, you know, that all has to happen in addition to the federal government taking steps for there to be a holistic approach to what's necessary. What wins you political capital is saying, you know, you'll end white supremacy and structural racism. What also wins some people political capital is rejecting, you know, critical race theory or saying reparations is divisive. So how do we create a common ground, and who is a part of pushing that movement forward? Where is the outside support? Where is the international support and organizing around reparations for slavery, as there was international, you know, mobilizing around, you know, establishing the Genocide Convention or organizing around the apartheid? Where is that kind of mobilization and pressure internationally, but also at the local and national level for communities, particularly those outside of the Black community, supporting this remedy to actually take place. It is possible, and initiative by a president is also possible in this context, knowing the political realities. We've seen this administration already take steps around the Senate to advance goals that they wanted to advance. So when will we determine Black people worthy of remedy?
Thank you so much. And then there is a question for Professor Shepherd, which is, Professor Shepherd, you were in the delegation of experts from the UN that visited Belgium and met with the Organization of Afro Descent and institutional representative in Belgium. Do you feel that the group of experts was heard? To what extent are you following the work of the Special Commission in Belgium?
Thank you, but I'm sorry, that is an error. I was not a part of the working group at that time. I never went to Belgium with the working group. I had long left the working group by then. So the person who took over from me as chair was Professor Ahmed Reid, as a member from
Okay, let me check if there is another question for you so I can directly address it.
I don't think I saw any. Somebody said, thanks for raising the issue of Haiti.
Yes.
Yes.
So thank you, Professor Shepherd, for powerful and just arguments. So glad you mentioned the case of Haiti, which so clearly illustrates the limitation of the current movement for reparations. When President Aristide made a formal request to France that it pay back the loot it stole from Haiti as reparations in reverse, the French government conspired with the US, Canada, and an assortment of international organizations in order to successfully has against Haiti, has that France and most international organizations still deny. This case is, I think, the litmus test for any reparation movements. What can you suggest, Varen, in the context of your remarks?
Well, I just have to thank the person for that comment and to I guess, endorse the statements that we have to focus more on Haiti because it represents a case of almost extortion. And we have seen contemporary impact of Haiti's attempt to repay that money that it had to borrow from a French bank, in fact, to service that loan, not the loan, but to pay this illegal extraction of its wealth. We see that underdevelopment follows extraction. So we have, and that's why CARICOM, the CARICOM Reparation Commission, and that is why the Caribbean is focusing on a development. I agree with my sister who said that all forms should be pursued, monetary compensation included. We're asking back for the 47 million pounds in today's money that represented the compensation to planters through what the British state did in terms of direct money to them, but also through the scam, which was called apprenticeship, the extraction of 4 more years of unwaged labor. That was a part of the negotiation, but it was put over as if it was some humanitarian way of transition to freedom, but we know it for what it is. So, and I also want to tell all of us that when Thursday comes around this week, be clear as to why like the March 25 is an international day for remembering the victims of slavery and the transatlantic trafficking in enslaved Africans. It was because Britain passed an abolition act to end the trafficking March 25, 1807, but we clear that ships arrived with enslaved Africans in the Caribbean way beyond 1807, and that it never legislated the abolition of slavery at that time. That was years later. Thank you.
Thank you very much. I think we maybe I can take one more question that I can address to Pablo, since he has received many questions. How do we go about holistically and critically deal with those who argue against the basic premise of reparations? This thought comes in as in the South African context, many of the former benefactors of apartheid state continue to deny the structural and cultural variance of the regimes. So how do we deal with those who argue against the basic premise of reparations?
So I think that one of the reasons why it is important not to reduce the debate to reparations, but to accompany it systematically with truth-telling efforts, is precisely to create some sort of demand for justice that may not be there in populations that have not been affected. Of course, there is, but I am not naive about this. This is a case of willful ignorance. It's not that it takes too much imagination to know the horrors that both accompanied and were left in the wake of slavery. But in any case, there is a difference between abstract knowledge, even if it's statistically and numerically, and the concrete knowledge about the horrors that human beings had to endure. So there's a sense in which reparations is not the same thing as an insurance policy against crime. Reparations is accompanied by an acknowledgement of responsibility. It takes many different forms, and those are forms that rest on the recognition of history. So going back to a point that I wanted to stress during my intervention, if social trust is important for us, and there are many reasons why it should be important, reasons that have to do both with the viability of a political project, but also with moral considerations about who we think ourselves to be, but also with the developmental considerations. The preconditions of trust require the possibility of historical reflection. And historical reflection is part of what is at stake in this discussion. So yes, there is a political dimension to this. It's an inevitable dimension in all processes that involve creating a new narrative about national histories, and in all processes that involve the mobilization of public resources. But one of the reasons why truth-telling has been important is precisely that it has been found out to contribute to that process of political mobilization. And we are right now in a very odd moment in which there is a lurch towards populism on the part of the political leadership of many countries, accompanied simultaneously by great popular mobilization in favor of progressive causes. And part of our task, I think, should be to provide the best possible tools for the debate that will be necessary in order to, as Siraj would put it, rehumanize part of our own history that has been buried in the past, and that to the extent that it is buried cannot be considered part of the history of democratic decision-making.
Thank you so much, Pablo, for these interesting remarks. I think we are 15 minutes late, so I think we're gonna end up here. But I think we have, I mean, the different contributions have been very enriching, and we came to, it's what we can hear is that the processes are complex. The processes are gonna take time. We have to think about the right mechanisms through which to address this question. But at the same time, we know that there is a momentum right now, as you were saying, Pablo, in a context where the political space is very polarized. So there are different political dimension and factors that we have to keep in mind if we want to address these questions very careful. Thank you so much. Thank you for your contributions, for your remarks, and for your time. Yeah, let's continue tomorrow. So just a couple of elements for the panel tomorrow. So tomorrow it's 9 a.m. Boston time, 2 p.m. for Brussels time, and then we will gather supranational actors, like we have the UN regional representative for on the Human Rights Office, and then a member of European Parliament, a representative from Open Society, and then one of our colleagues from Avocats Sans Frontières. Quite excited also to continue with this discussion on the opportunities that we are having now, and what can we do from that. Thank you very much.
Thank you.
And thank you to the interpreters and MVP and all the team who are working behind it. It's a lot of work. Let's stay in touch.
Thank you. Bye.
Bye.